Okay, hi everyone. Prep time is over. Okay. Hi, HSE, Belgrade, Warsaw, judges.
Excuse me, there is echo. Could we do something about it?
Okay, hello, can you hear me?
Yes, now we can.
Okay, fantastic. So, cool. I think we've got everybody on this call, so we'll just start with introductions. Hi, my name is Enting. I'll be judging the debate. My preferred pronouns are she or they. I'm going to let the rest of the judges introduce themselves.
Hi, I'm Alexander. My preferred pronouns are they, them.
Hi, my name is Sharon. I prefer he.
Hi, my name is Hasna. I prefer she.
Fantastic.
And
So,
yep, hi, I'm Spencer, preferred pronouns they, him.
wonderful. Cool. So can I just check that we've got the correct teams in the room and do introductions and speaker order at the same time? From opening government, do we have Belgrade C?
Yes, we are here. Surgeon speaking first. Philip speaking second. No preferences for both of us.
Thank you. Could I get the other speakers to just introduce themselves, just as a mic check as well, please? So to make sure we can all hear each other.
Yeah, I'm Surgeon. I'm speaking first, but we are going to use same device. The other one is just for backup.
Gotcha. Fantastic. From opening opposition, do we have HSCA?
So I'm Nikita, I'm speaking second. Igor is speaking first. He is in the call, but he doesn't say anything.
Okay, maybe you would want to just get in contact with Igor to find out if the microphone is working. While I do the rest of thank you, while I do the rest of the introductions. From closing government, we have Strathclyde A.
Yep, Andrew, I'll be Iron Manning this round because my partner is absent and he, they are my preferences.
All right, thank you. And from closing opposition, do we have Warsaw A?
Yes, Maciek speaking first, no preferred pronoun. Tomasz speaking second, no preferred pronoun.
Thank you. All right. HSCA, did you manage to get into contact with your partner?
Well,
she... Right.
Hello? Yes?
Can you hear me? Yeah.
Yes, we can hear you now. Fantastic. Okay, cool. So
Enting, you muted.
right. So everyone's in this call and everyone can hear each other. So just a reminder that if you're asking points of information, we have a chat box. And please keep an eye on your time. Even if you're not speaking, it's very important to look at your time so you know when it is appropriate for you to ask points of information and when it is not. So without further ado, I'd like to invite the Prime Minister to give a speech not exceeding 7 minutes. Here.
Am I audible? I'm starting in 3, 2, 1, go. Okay, honorable panel. When status quo allows people to create outside of the court settlements, but we are not allowing them for this to be the only way how they can settle themselves. What this mean? This means that each one sides in this process can actually choose to sue another person on the court. We are for that. If this is the distinction that we need to choose, whether these are going to be the only way how people can actually go into trials against Amazon, we are saying it is much preferable to actually go into real court and to actually sue them there. I'm going to do 4 things in this speech. Firstly, I'm going to show you briefly how this would actually look like a model. Secondly, I'm going to explain you when this is actually happened, when like people suing Amazon. Thirdly, I'm going to explain you why people are in a lot of cases coerced to accept these contracts, even if they're like bad for them. And thirdly, Fourthly, I'm going to explain why this is going to be extremely like bad and harmful processes for the people who are actually suing Amazon. So first thing first, about model. We think that this is pretty easy to say. We're going to ban all court, meaning that if you sue them like in previous time, you're not going to be able to repeat that on normal court. But pretty much for every other contractor, you and Amazon are going to be forced like to create new contract, or if you want just to put this thing out of your contract, just for this to be only on regular court. So when this is actually happened, second thing, we don't think this is quite often something that is happening. But the problem is when this happens is that third-party sellers think that they're damaged from Amazon. This is happening in two situations. Firstly, when shipment is late or broken or something, and Amazon is pushing them to like pay remedies for that and stuff like that. But more importantly, when this is happening is when Amazon is actually copying some feature. Amazon has all information. This is crucial. Amazon has all information on what is shipping, but more importantly, what is selling the most. Meaning Amazon has its own shipping and its own products on Amazon Essential, meaning that in a lot of cases they're copying these products and selling as their own, meaning that they have all their own Amazon batteries, for example, and in comparative with like Duracell batteries. We're saying that this is like taking private rights from them, and actually you're not being able to do anything about that. So going into second argument, why these people are forced to accept this contract? Three structural reasons for that. Firstly, in a lot of cases, meaning if we don't speak about like China, in a lot of other countries, Amazon has pretty much all times monopoly. What this means? This means that he has biggest reach, but in a lot of cases, he either buys or kills his competition. This happened with eBay, this happened with Uber Eats and stuff like that. Pretty much with every company which like try to harm Amazon and to take their like market share, they're either buying them or like killing them. Know that in all of these sort of situations, you as a consumer has all incentive to go into the biggest thing that you can happen. Secondly is that Amazon has vertical chain of supply chain that is vertically integrated, and this means that it has most seamless delivery, meaning that a lot of people actually want to buy from Amazon and not to buy from all other companies. This is maybe good for the consumers, but for the people who are selling through the Amazon, this is extremely bad because they're like basically pushed to take worse conditions because this is their only alternative. Secondly, you cannot break through as an independent. You can like basically two things that you can do. You can create either your own site. I'm not sure how you could like compete with Amazon with your own site and stuff like that. Secondly, you can try to with brick and mortar, either like build your own or going into Walmart like their partner. But for all of these chances, you need much greater like resources to put in this, and you has much greater chance for people to actually buy products for you, meaning that your cost benefit analysis is much smaller when you need to give smaller portion of your money to the Amazon. So why we think this is going to be a bad process? Before I go on that point, I'll take closing if you have anything. Opening? Okay, nobody wants to engage. Okay, so why this is going to be bad process? This is crucial for the debate, I think, because lawmakers which are creating these contracts in a lot of cases create the contracts which would benefit the Amazon, meaning that these guys who are creating contracts are the ones who are actually working for the Amazon, but more importantly are the ones who are actually going to be involved in these prosecutions. They're probably going to be defenders for the Amazon and stuff like that. Moreover, they have much greater money and they have much like better lawmakers and better advocates and stuff like that on their side of the house, because they as a company has much greater pool of money they can actually invest in this, and basically they are already paying these guys and you need to give your own money. Secondly, in a lot of cases they have their own judges. Know that we are not saying that this is always going to be extremely biased, but in a lot of cases, even if these judges doesn't want to be biased, in a lot of cases they're like either like subconsciously or like really afraid of their job. In a lot of cases they cannot like, even if like it is always happened that Amazon is the one who is guilty, is the one who needs to lose this prosecution. In a lot of cases these judges are not going to decide that their company is the one which are losing, because in a lot of cases they could lose their job. Secondly, they know on which basis you can sue them. Basically, this is like either stealing your property, like patent rights and stuff like that, meaning that they know that they're going to put something in your like contract clause that this is something that you cannot sue them on. This is something that is going to be in favor on them. Know that these lawmakers know what Amazon is doing and how Amazon is actually taking the rights and taking this stuff from the companies. You as an individual in status quo doesn't have that much because you want to break through. You think what you're going to sell, how you're going to sell, how you're going to market that. You don't have that great pool of time and that great pool of money to like pay the experts to actually shape this for you. But fourth reason, and this is pretty much the most important reason here, you don't have incentive to sue them in the first place. Know that this stands independently. Even if opening a position or closing a position proves you that these courts are going to be the best courts ever and they're going to be the less subjective, which I think it is not likely to happen. But even if they prove, you as a person has no incentive to actually sue them. Why? Because you know that you are going to be sued on Amazon court. You know that even if this is not correct, even if like they buy some independent judges to sue, you're always going to think that this is something that is theirs, meaning that you're never going to believe that you can actually prove. And even if you prove, you're never going to believe that these judges are actually going to give you credit that you win on this. And this is going to cost you a lot of money because you're not like Google, which is going to sue Amazon. You're like some small SME. In these cases, you're losing a lot of your money to the trial, which you're likely to lose. For all of these reasons, we think that this is really harmful for the SMEs, and we are proud to propose.
Great. I thank that speaker and call upon the leader of the opposition, here.
Once again, I'm unaudible. Yes, no. Okay. Just a minute. Three, two, one. We think at first we have to make some clarification according to the motion, because I think the Prime Minister failed to explain us what is the motion about. Actually, what's the issue here? There is a shop who sell these goods on the Amazon. Amazon is just a marketplace where they post the information about different shops, about the prices of goods, etc. It's like Google, which promotes the different magazines in its search engine. But I think the issue, who use this court in status quo? This is a court. This court is not about Amazon suing against these third parties. It is third parties who is actually the shops suing against the usual buyers who buy stuff on the Amazon marketplace, and they have a claim against that. I think this is extremely important to emphasize. What we do not want to emphasize in this motion the rights of third parties to have this ability to suing, but we emphasize actually the consumers who buy these goods and they want to have this court because it's extremely useful for them to having that. First of all, why we think this is extremely important to suing, to have a court for suing if your goods will not delivered, etc. We think that this issue, like the parcel were not delivered, for example, for you, can be extremely important for you. For example, if it's you are a student and you order a laptop on Amazon and you get the broken laptop, you definitely need the compensation because you, for example, don't have the money to buy the new one because it's extremely expensive, and you have to receive immediate response from the shop, like to ask for another laptop, etc. I think because your study, for example, depends on this laptop, and your future career will not be so. You will fail, for example, exam in your university if you will have this laptop. Or, for example, its car, which you buy, it's also very expensive. And if you work as a taxi driver, it will be extremely important for you to solve this dispute as much as possible. We think that your alternative world, where this court, international court, don't exist, you put too much pressure on the consumers who actually suing against the third-party sellers for a few reasons. first of all, we think in this case, these third parties will be able to to sell low quality goods and not be responsible for that. Why? Because simply balance of power will be on the side of these third parties. Like clients can't just refuse to go into a court, because first of all, it's time consuming, because it requires several months to settle a dispute in a court. And therefore, if you are, for example, a student or you are working, you don't have a time to visit this. But moreover, it is USA. It means that it is extremely expensive to go in a court. For example, it may cost hundreds of times more you spend on the cost on suing actually in the court than the actual price of this good. And we think this result is not guaranteed in this case, because the court probably will be on the side of the company, because the company have more resources, like they have more money to suing against you, they have more lobbying power, or they have a kind of trade union which is can help them settle this dispute. But we think the Amazon contractual court, there's extremely easy to resolve these issues. Why? Because we think what Amazon actually wants. I think it wants, as it earns its money from the commission from each sale, it wants the increasing the amount of sales on this marketplace. But moreover, he also wants to preserve the sellers, like shops, to stay on this marketplace, because there are another options like eBay or Alibaba, which also works in USA, for example, or Canada, where the Amazon presented. But we think that in this case, there is a strict intention of Amazon to find a balance between the client and the shop. And moreover, this is the only actor who has a capacity to work on such amount of claims, because the amount of claims is very huge. It's like 2.5 million per shops which exist. Therefore, it's like approximately several millions of claims which exist. No single court is possible to work with that amount of claims. But Amazon is only actor who is interested in settling this problem, and we think this is extremely important. But how it reduce the cost? It is very simple. You don't have to pay nothing to Amazon, because it will do automatically for you. But moreover, it will be it work on your claims very quickly. It's not about like several months on the which you spend on the court. It's like few days, maybe a few weeks, and your laptop will be come back, or you will get compensation, because otherwise the Amazon will punish this shop and, for example, decrease its rating, or you can decrease its rating by writing this on. Moreover, you cannot delete the commentary which Amazon consider as a valid reason to punish you. But if without this course, you will be able, as a marketplace, to delete this commentary and avoid reputational costs. Therefore, it's also increase the chances of not solving this problem. I think we also have to understand that because of the amount of deals, there is no single actor who actually afford to work with that. And we think the Amazon is only actor who is capable to do that without the additional cost, which is placed on the buyer. For all of this reason, for the reason that we have to prioritize buyer here, and this arbitrage is absolutely necessary, we're very proud to oppose.
Great. I thank that speaker and call upon the Deputy Prime Minister here.
Am I audible? Great, I'll start in a second. Two questions in this speech. where on the comparatives we will get more fair and decisions for the third-party sellers on Amazon, and second of all, whether and where we will have more innovation and more third-party sellers actually managing to sell stuff and to thrive and innovate in a more prudent way. But before that, few points of rebuttal. We mostly think that opening opposition is pretty much uncomparative here, because notice one thing. Amazon can take the risk in the first place if something malpractice occurs, and I don't know, somebody gets a worse laptop or anything like that. You can still write it in your contract that you're gonna they're gonna take the amount of money if you were lying or anything like that. But you as a third party on the comparative will not sue them on the internal Amazon court, which is always biased in favor of Amazon because of the reasons Surgeon gave you. But now you're as a third party seller who was damaged by the Amazon, who thought that you were the one who is actually inflicting harm on them. You're gonna sue them on a, I don't know, civil or government court that is actually existing right now. Because we say to you, as Surgeon explained to you in his speech in the first place, we allow people to have off-court disputes and everything like that, but we never. Oh crap! Okay. We never allow them to only have that option. And this is the thing, you are coercing those people to actually have that option. And this is not only coercion this is something that was allowed by the state and should not be done because of the reason that Surgeon gave you, because Amazon has monopolistic power, because it has a lot of ways to infringe on your rights, and you have no ability to actually have recourse towards them in their court. This is highly problematic. Okay, another thing, most of those people who are third-party sellers have no incentive to actually be bad and or lie. Why so? Two reasons. First of all, this is the only way to access your consumers, as Surgeon explained to you, and I mean, this is the best and cheapest and easiest way to access them. And second of all, Amazon has a lot of checks in the first place to actually not allow you to lie and represent yourself in a false way. Therefore, you are not going to be on the platform if this happens. Third of all, send goods to consumers. Most of the people who do malpractices can be banned in the first place if they pass first checks. They would be stripped from those Amazon services. They would be sued and everything like that, taken their money. But the dispute, if third party decides to actually go on court, will comparatively go in a more neutral way, as we say to you. So, and second of all, we say to you, Amazon has strong checks and balances. Therefore, they would be insured to make those things reliable and everything like that. So that is the thing. We say to you that on the comparative, people who are suffering mostly in this place are the third party developers. That is the thing that they need to defend. We say to you, maybe Amazon courts are faster in the status quo, but those decisions that are given on the Amazon court are definite, and you cannot appeal to them or anything like that. Unlike the state courts where you have a right to appeal and everything like that. Maybe this is slower and this harms a third party in a milder way, but notice one thing, you have detrimental harm to those third party sellers, especially to the startups, SMEs and everything like that. This will not harm probably Royal Philips of Netherlands, but this will this will hit most of the startups who are beginning to sell their products that could be sold on Amazon. So why this is bad and unfair? Because we explained to you a few components why this is bad and unfair. This is unfair because you're coerced to sell your products on Amazon, because Amazon for once has a monopoly. Second of all, your alternatives are bad, considering that you cannot enter brick and mortar stores because of your low negotiating power, and because other alternatives like you making your own platform are simply not there because you do not have the reach and enough money to actually market yourself to compete with Amazon and eBay. eBay, even if you say there are competing platforms with Amazon, we say they are shitty in a way that Amazon made them obsolete in a way that you cannot actually reach enough people which you would in the first place. So we say to you, because this is a monopolistic way, because you're coerced to do this, this is in the first place unfair. Now, that is the reason why you will accept the deals which are unfavorable to you in the first place. Why so? Because notice one thing, Amazon has incentive to actually make these deals, these contracts and everything like that, mostly favorable to them because they can predict what will happen, as Sergeant explained to you and everything like that. The shipment part is not so problematic as it is the copying of features that are essentials for their competitors to compete. Now, Amazon Essentials can actually copy each and every feature that is making someone having their unique selling point and sell it as their own. It would be really hard to prove on their court that this is how do you say, intellectual property stealing and everything like that. So in that way, because the laws were constructed like that, you cannot sue them in a regular court in which someone could actually interpret this. And because that are the reasons why this is bad. Before that, I'll take closing. Opening? Fine, no engagement whatsoever from any side of opposition in both of our speeches. So we say to you, when you're coerced to actually sign these deals, when you do this for the startups and everything like that, when they copy you, they simply, because of their algorithms and everything, can push their products. When they push their products, they expunge your product, or simply because they have more ability to manufacture them more cheaply, they're simply going to outbid you. Therefore, more of the people will have less money. When they have less money, you're going to have less innovation because you cannot harness profit from your innovation in the first place. So you're going to have less people actually willing to engage in actually creating a startup or anything like that. You're going to have less people who are entrepreneurially spirited in the first place, because now they know that they need to sell via Amazon, and they are going to know that they're going to be disputed in those courts where they are not in favor of them. So you stifle innovation in a way which is detrimental to the most of the developing countries and everything like that. Because we say to you that on the comparatives, maybe our courts are slower for the third party and everything like that, but they're on the comparative more fair and have more ability to not stifle innovation. Because all of these reasons, incredibly proud to propose.
Great. I thank that speaker and call upon the Deputy Leader of Opposition, here.
1, 2, 3. Hello. Oh, first of all, I would like to get right the criteria how we should judge this debate. In the capitalist economy, you are not entitled to run a business. You are not entitled to sell anybody anything. The only reason why you should be entitled to any profits or any business is that you're able to compete and that you're able to deliver to the consumers a service which is beneficial, which is better than the others. So we do not care if third-party sellers suffer per se. It's not, we care, the only metric to judge this debate is the consumer experience. In which world the internet, well, the consumers will be able to get their orders more cheaper, in which world the consumers will be able to get their orders faster. So yes, third parties suffer, but what? Now, first of all, I'd do a small bit of rebuttal about copying, etc. So when you infringe on intellectual rights, ICUPI, I take it later. When you infringe on intellectual rights, you are infringing on the manufacturer's right, and the manufacturer, not the seller, has the right to take you to court. So this is not the debate about patents and stuff. Now, Andrew, please, UPI.
Do you have a right to free and independent contract enforcement?
Yes, and when you sign, you are not obliged to sell anything on Amazon. So when you sign the contract, right? So the meta level of the contract is free and independent. So it's just if you don't like this type of contract, just as if you don't like the fee the Amazon will make you pay, you just don't sign this contract. So second, what is the how do we harm the consumer in this resolution? I will show you 2 things. Consumers will pay more and they will have a lower speed of their dispute resolution. Why will they pay more? It's simple. So the government concedes that the real courts cost more money, right? And take more time because they're expensive lawyers, there is documentation cost, etc. So what happens is that those costs will be factored in the price, right? Or in the price which a person pays to have the goods, no matter how it's split between the third party and the Amazon, the person, this is paid out of the pocket of the consumer. So in the world, so all the additional costs will be, so what the opposition proposes is to pass some money from the pocket of consumers into the pocket of the third-party sellers, which I remind you, they do not, they are just the middlemen. So then, so with the world without the third parties, in the world where Amazon works directly with the manufacturers, and like all other big retailers do. So this will not, so this is not the result we want to achieve. The second question is about the dispute resolution speed. Is if right now, if a person complains to Amazon, they can be sure that they can receive a speedy resolution because Amazon is sure that it will be able to receive a speedy resolution in the case of a claim for the between it and the third-party seller. Now, now what will so they will have to wait. No, let us now address the point of monopoly. First of all, Amazon is not a monopoly, right? You have offline retailers, you have competitors like Best Buy, and what's more important is that you have very low entry cost. If Amazon starts to abuse its position, then it is very easy for you to set up a competing internet website which will be selling stuff. You will not have the advantage of the scale which Amazon has, but at the same time, this ability to very cheaply and quickly create an independent internet shop with is what restricts Amazon's ambitions from profiteering. So they are not monopoly now, and even if they will become more monopoly later, they have this is a market with a very low cost of entry. So the only profit they will be able to extract will be this. And for finally, this does not really resolve the question of Amazon being a monopoly, which is harmful to the consumers, because Amazon, as Amazon is powerful, yes, and if we don't understand how making it more attractive towards third-party sellers will make it less competitive against the external rivals. And so finally, about the startups and this character. So first of all, we do not again see that you have a right for a distribution network as such. Just if you have a marketable product, then you can go to Amazon, you can go to Walmart, you can go to Best Buy, you can go everywhere. You can set up your own website. You can do direct to consumer marketing via social networks. So this is completely not true that it will starve innovation. What's more important is what will happen if the resolution passes. That Amazon and third parties, the Amazon has to factor in the legal costs into the contract, right? So when you sign, since you do not really reduce the market power of Amazon compared to the third parties, then they will have to compensate, right? So right now, if you pay a fine for late delivery of $500, then in the future world, the Amazon will say, no, you will pay a fine of $1,500 because they will have to factor in the costs of actual litigation to get this fine. So even the benefit to the third-party sellers is not achieved just because you do not resolve the core issue of negotiating powers. You will just shift the burden from one part to another part. Thank you.
Great. I thank the Deputy Leader of Opposition and call upon the Member of Government here.
Give me a minute to make sure my notes are in order. see, let me get my timer up. Is everybody ready? Right, let me just go 3, 2, 1. I'm going to start with extraneous rebuttal, then rebuild some, fill in some of the analytical gaps left in by opening government as to what the comparatives are and like what, not just why specifically is Amazon kind of bad, but what specifically is good about the court alternatives and why do they do things specifically well. Thirdly, the impact of monopoly and like why specifically this is good, and then maybe if I have some time, some extra principles. But first of all, like rebuttal. So Amazon is so much more than just a monopoly, right? A monopoly is a company that has a very large share of the market to the point that it is difficult to compete with them. Amazon is the very marketplace itself. You have no option but to go to Amazon to get people to even know that you exist. Note that the business model for Amazon is not so much that people go to Amazon because they know Amazon have specific product X, but they go to Amazon because they know how Amazon have products and they will find what they are looking for once they are there. What this means is that you have no ability, no matter how low the entry costs are, to like have a meaningful business model or alternatively, because if you go elsewhere, then you are going to find yourself in a situation where people do not know that they should even be looking for your product. I will take a POI at 5 minutes and no sooner. So what this means then is that if you go elsewhere, your product does immediately die. Note again that these are not just, this is largely not just like small companies, but small companies in countries away from their consumer base. So brick and mortar is not just like kind of expensive. It is physically impossible for a company that is producing goods in China, that is producing goods in India, to start opening physical malls in the USA, right? That is completely outside of this debate for these companies to go elsewhere, which means functionally they have no choice but to go into business with Amazon. What does this mean then? So OG tell us a lot about like the fact that Amazon will never adjudicate fairly, but they don't fill in enough of the gaps as to why specifically and how. Note that when the judges and the lawyers are literally employers of Amazon, even if Amazon doesn't just outright bribe them for the results they want in the case of dispute, even if Amazon doesn't do that, which I think they probably do, they can they can dangle things like future prospects in front of you. Like, do you want that next raise? Do you want that next promotion? Note that they only, because they have a large pool of potential judges to be drawing upwards, they can basically select only the most loyal and Amazon favoring adjudicators to ever go forward, and that means that never will a dispute be settled outside of Amazon's interests. And even if you do get some paragon of virtue, I think that there is just a massive discrepancy between the amount of influence that Amazon has and the amount of influence that these smaller companies have. Literally just access to you to say during your workday elsewhere that, hey, dude, you remember that case? You should totally do it on our side. And the fact that you are thinking in first instance from the perspective of your own company means that it is basically impossible for these judges to ever be independent. Well, on the comparative, judges in state-given situations are much more independent. Like, sure, there are countries in the world where corruption happens, but independent of a specific country being named, international courts and courts, broadly speaking, have long institutional histories of valuing independence first and results way down the line, right? Note not only this, but there are a variety of non-court, non-Amazon options. I can't believe nobody's mentioned tribunals yet, but you don't need to go through a lengthy court legal battle to get a contract dispute solved. Usually it goes to tribunal, which is very informal, very cheap, very efficient, usually gets people what they want, but notably is everything that Amazon wants to say this tribunal process is, their process is, but without Amazon literally being able to say, hey, look, I didn't do the thing, and oh, if you say that I did, I will just tell you again, no, I didn't, because I am the person making the decision, right? There's no vested interest there. So on comparative, you can actually get very quick, accessible justice. Like here, they try and slander international courts because they think that this is a thing that debaters do. But I would like to remind you that even if international courts are bad at dealing with war crimes and stuff, they're actually very good at dealing with contract breach, because there is a wide number of incentives for countries with international trade treaties to want those trade treaties to be enforced strongly. And there's a lot of quid pro quo in international relations that allows for these international courts to be very effective. So what is the what does this mean in practice? It means that like these third-party companies, the very small ones, get completely screwed over. It means they have very little incentive to innovate. It means they have very little. I'll take a POI from closing if they have one, but if not, okay, cool. Oh, go ahead.
Okay, so I think that what you are missing is that they operate in various legal systems, in a variety of in common law, internationally, in any like
yeah. So like there are a variety of different. Sorry. Yeah, there's a variety of different legal systems in which they operate, and any given one of those legal systems holds less of a vested stake in proving one specific side guilty than Amazon did. Like, regardless of whether or not you are a common law or a civil law system, like it's just going to be better than letting the person who is stealing from you or like screwing you over decide they're not, right? Principles. I think that whatever state it is that is doing the adjudication has a principled obligation to actually enforce those laws and enforce those contracts that are being held, right? We think that obviously a contract is entered into. I tried to say this to OO, but they didn't listen. They just said that, oh, Amazon can enforce their own contracts and be totally impartial about it. No, we think that obviously when Amazon gives you an unfair verdict on a contract dispute, that is a breach of contract in and of itself, and that those people who have entered into that contract, who are rightly and justly allowed to rely on that contract for their well-being and for their business, obviously have a right to a fair enforcement of that contract. We think that that is the duty of whichsoever court may have jurisdiction here, but like it is the duty of the states to intervene here. What this means is that there is like just a principled right there, and cool. So what does it mean if you just let the big bully the big bully decide that they're not guilty all the time? And firstly, it does just give you a massive competitive advantage that nobody ever wins lawsuits against you. I think that that is very intuitive, and that an op bench have so far missed that there is a lot of expenses to being sued. Like if you lose, you have to pay for the other side's lawyers, you have to pay for the damages, you have to pay for the products. That is a large number of payments that Amazon can choose not to do. And notably, that if they adjudicate their own things, they are more willing to make those cruelties, like they are more likely to breach contract, and they are more likely to attack and screw over their business partners when they know that they cannot be held accountable for it. Proud to propose.
Great. I thank that speaker and call upon the member of opposition here.
Okay. Am I audible? Because I have some technology issues and I am worried that this may affect. Okay, cool. Okay, so I'll start in 3, 2, 1, go. So I agree with both governments that capitalism is bad and Amazon is like the badass of capitalism. But what are you doing would precisely make it worse, because you believe that when you just abolish those courts, Amazon would magically be like a company that now has to follow every law that would not influence the contracts they are making, which would not influence the legal systems that they operate in. And this is something that I would like to prove. Why those courts, why those internal courts are actually pretty good deal, and why Amazon would fuck the little guys on the comparative. So let's start with the comparative. Like those courts which the closing government was talking about are, like, I would say, rare, because usually Amazon like is based in places of specific law construction. For example, in European Union, it is Ireland. In the United States, there are some specific states that have a specific law enforcement that is acting in their interest as a big company, and not to mention the common law systems or arbitrage all around the world, which is like, if you want to go to court with Amazon in the United States or in the common law system, you probably have to invest much in it. It is expensive, it is time consuming, and many other legal systems where you don't have like tribunals that the closing government was speaking about. And also, like, just bear in mind that Amazon still would make those contracts with these people. And if we believe opening government, which I think we should believe, that Amazon is a monster and uses their force extensively, therefore they would probably push those legal traps in the contract. So probably the tribunals that favor them, or specific law construction of this contract, which would make it pretty unclear and pretty hard to interpret. And therefore, if you want to go to court with Amazon as a third-party seller, then you have to counter and win with the biggest corporation in the world, and it is very expensive. It is time-consuming, and you need a bunch of lawyers or even several corporations of lawyers that would work for you. And even if that is the case, you are very unlikely to win or not go bankrupt in the process. So this is why we believe that pushing those people, this is the first reason why pushing those people in this legal systems is pretty bad. So I'll take you later. So the second thing is that because they still have power and they still can push several unfavorable things in the contract. So in arbitrary courts leaning toward their favor, it doesn't matter if it's Amazon branded. It just matters if they are leaning in Amazon's favor and pursuing their interests. There are many arbitrators around the world, and I think that Amazon would find some that would suit them. And if they are so monopolistic as the opening government claims, then they would do that, and everybody has to agree to this parts of contract, right? So the second thing is that those legal systems are pretty complicated and legally established contract, which are negotiated by the Amazon for the benefits of Amazon, and therefore the whole construction of this contract, if it wouldn't be a standard contract for all Amazon sellers, it would be probably pretty much done by the biggest company in the world with the best lawyers and better local corporations, which they would have to be obliged to, and therefore they would be probably worse off on your side of the house. Second, and to sum up this issue of comparative, I think that out of many sellers, of which many, like you mentioned startups, which of course they have some capital, but they are not like absolutely rich to actually, if they exist for 2 years, they wouldn't go to a court battle with Amazon for 5 years in some other country in which Amazon operates in the first place. I think that also, like, an individual sellers that are selling through Amazon, they would also probably not be even able to sue Amazon on such matters. So this is the comparative. So let's start what those courts are really about. So we believe that those courts are basing on Amazon's incentives, and this is probably true, but we don't think of them as like some badasses that just get paid to strike the soul of good workers in the first place. We believe that the biggest issue Amazon has is that we do not believe government on the point that they do not have competition and they are monopolistic. We have big international competition like Alibaba Group or eBay. We have many regional competitions, like for example in our country, Poland, there is like Amazon is out of reach because we have a very strong and similar company. So we believe this doesn't mean they do not have the force to force somebody to actually change the contract, but we believe that what they need to do is to act responsibly and remain a good option for people to sell stuff. And what they need to have, therefore, is they need a good PR and effective way of treating mismanagement in their case. And this all aims to being perceived as open, progressive, and careful. And we believe that they need to have. They also want to be invested in, sell their stocks, etc. Closing.
You've given us a bunch of reasons why these state courts are imperfect, but never a single bit of analysis as to why Amazon doesn't have all those flaws too.
Okay, but I am just explaining it now, so your question is redundant. Okay, the next question is like, because they need a good PR and be perceived as competitive and a good option to do business with, they need to be as quiet and effective as possible with treating mismanagement. And those arbitrary courts, you of course can still take this case out. And this is something Amazon doesn't want you to do. So they do not want to take every penny out of your soul. They want to make a deal that would keep you quiet and make you happy. And this is like the primary reason of existence of those courts. And we believe that in this world with such a comparative, this is actually a pretty good option for those people. It is in the interest of those arbitrary courts and the interest of Amazon for you to be pretty happy if you keep quiet and effective and do not need much of a lawyer attention or would not take this case public. And we believe that it is if discrecy and effectiveness are lost, and this is the case of banning those effectively those courts, then Amazon does not have any other incentive but not to take every penny out of your soul. And I agree with government that they can do that, and therefore we believe that it is a terrible idea to do such strange things. Thank you.
Great. I thank the member of opposition and call upon the government whip. Here.
It's me. All right, give me a sec to figure out what my partner's notes are. He's got really awful handwriting. Cool. Just 1 second. I'm going to start with some extraneous rebuttal, then kind of rebuild the case that my partner kind of goofed, and then, kind of weigh up the debate as a whole, as the whip's supposed to do. So firstly, like this incentive to make the plaintiff happy, to try and to stop them from dragging it out or whatever. This incentive is entirely contingent on the plaintiff being able to do anything about anything that Amazon does. And when it is held entirely in Amazon's court, we have not heard a single reason as to why Amazon cannot just entirely ignore literally every sentence that comes out of the mouth of the complaining party. Like, we literally have had not a single reason to believe that Amazon will not literally put in earplugs and ignore every word out of your lawyer's mouth. So I don't think that there is any capacity for those companies to drag out these affairs, for those companies to whatever. The other thing that they said was that Amazon is contingent on PR, and to be able to attract investors and to attract customers, they need to look relatively friendly. I think this is false on a number of levels. Firstly, customers. Do you think anyone, when going on Amazon or when reading the news, is actually going to pay attention to Amazon third-party contract enforcement? Because, we're debaters. I'm pretty confident that very few of us even knew that this system existed. We're pretty well read up on our stuff. I don't think you can ever assert that the averagely informed voter or the averagely informed consumer ever makes that way up, or even knows that that is a thing that exists when deciding whether or not to buy a t-shirt, right? I think that this is just entirely out of the debate. Secondly, to attract investors. I think that is actually very harmful to their case, because investors in Amazon want Amazon to be strong. Investors in Amazon want Amazon to be able to crush their opponents, to get the cheapest prices they can, and to never have things. I'll take POIs later, thank you. I think, therefore, that if Amazon is able to strong-arm all complaints against them and just entirely ignore them, that makes them even more attractive to investors. And so, to the extent that it is literally more profitable to be able to ignore all complaints against you, I think we can reasonably expect that, Amazon gains investment and gains, PR, I guess, by being more cruel, by more evil. The comparative is not between capitalism and a good system. The comparative is between capitalism and mercantilism, which was unfortunately worse, right? So what then have we brought you? So first of all, generally speaking, the opposition is kind of throughout this debate, opposition has mostly missed where the debate is. Opening opposition decided to talk about consumer lawsuits and stuff quite a lot, which is obviously out of this debate to the extent that this is only a mechanism that enforces between third parties, which is sellers, and Amazon. Whenever a consumer makes a complaint, they make a complaint against Amazon, and this tribunal system is not what happens because they just go to regular court. That's not in the motion, right? I've already dealt with closing, so I think I'm going to just try and do a bit of weighing between me and my opening, right? So opening they're really good, actually. It was kind of tricky thinking that stuff, but the nuance that I did bring, I think, is sufficient to win me this debate. Right? So, like, first of all, that they didn't fully characterize the distinction between like what a monopoly is and just the fact that being the market itself is so much more coercive. In a monopoly, it is just difficult to contend with the stall next door. In the case of Amazon, you literally have to pay them to even turn up. You have to be willing to cede to their demands to be even allowed to sell your product. Alibaba is very small relative to Amazon. eBay is tiny, not even competing with them directly. And I can't remember, maybe they even got bought by them? I'm not sure. But like, generally speaking, these kind of asserted counterfactuals are the kind of asserted counterfactuals that only specifically debaters and maybe econ majors will know about. I think that broadly speaking, we can expect the average consumer, when they want to buy products online, to not say online marketplace and have Alibaba turn up. They just type Amazon because their name recognition and their age in the internet is so much longer. I'll take that POI from, I think, opening.
Yes, so Amazon cannot ignore all complaints because it still has to offer a profitable deal to third-party sellers. If Amazon wanted third-party sellers gone, it can just stop allowing third-party sellers altogether.
So like the fact that a deal for a third-party seller is profitable does not make it just that the Amazon can breach their own terms of contract whenever they want. I think this is something that has been missed in the framing for all of op in this debate, right? Like, even if Amazon is causing some marginal amount of profit aggregate for their third-party sellers, that does not mean we would not prefer them to be less shitty and give more favorable deals to their third-party sellers. The fact that some amount of profit occurs is not a reason for them to shut up and stop complaining when their contract gets breached. The main framing issue that opposition has had throughout this entire debate is about like what terms of contract is getting breached. So opposition have focused entirely on like the idea that, oh, Amazon, like you agreed to this contract, you need to stick to it. The difficulty is that the main claim from proposition is not that this is third-party sellers not abiding by their deals. This is Amazon finding their ways to get out of the contract that Amazon wrote. Because no matter how coercively and favorably you write your own contract, you are ultimately going to have some situations where it is unfavorable for you to follow through. And note also that this extends past contract breach to other forms of illegality, such as like other people have mentioned, IP breach and like just straight up not supplying goods and whatever, that is independent of whether or not Amazon wrote the contract, just straight up illegal. Having Amazon be able to adjudicate on those issues is obviously not responded to by any of the claims that have been made on opposition so far. What is the other thing that I brought you? I brought you like the principled fact that obviously there is just a right to have your contract enforced fairly. To the extent that if I agree to do something with you, if I agree to trade you a bar of chocolates for like a Magic the Gathering card, like I may reasonably expect to rely on that deal. I may reasonably expect, regardless of whether or not the deal was good for me or not, that that deal be enforced and that deal actually occur. If I hand over the bar of chocolate and then you run away with my Black Lotus after realizing it's kind of valuable, like I am reasonably expected to like it would be unfair for you to be able to just say, to tuck the chocolate away and say, don't have it. Oh, who are you going to complain to? Me? That's obviously like unconscionable, right? We think that there is, therefore, for the extent that contracts are ever legitimate, bound entirely by consent, there must be some mechanism by which they can be adjudicated fairly. Opposition have not told us ever why Amazon will do that. We have many, because obviously formal legal systems are quite expensive. Proud to propose.
Great. I thank that speaker and call upon the opposition whip here.
Okay, am I audible? Wonderful. I'm going to start speaking in 3, 2, 1. Well, first of all, the OG started off this debate with a bold claim that Amazon copies business models of third-party sellers. Well, they sort of do, but not in the way you think they do. It's not like they see a cool business model and go like, oh snap, we need to copy that. What they do is they aggregate macro data throughout the whole platform and loads of internet stuff. And this is an absolutely different issue. It is outrageous, but they don't copy these business models. What they do is they aggregate and use big data in a very outrageous way. But this is out of the scope of this debate because these kind of issues would not even go to this sort of arbitrary court. They are out of scope of such proceedings. So this kind of copying happens in a different way and is adjudicated in a different way by different courts. Second of all, the OG said the Amazon has an unfair advantage due to the powerful legal of Amazon. Well, they do have that, especially in open court, because open court procedures are much, much more complicated. They vary from country to country, sometimes from state to state. They require huge litigation. What Amazon does here, actually in advantage of the client, of the seller, what they do is they give you a very simplified procedure which you can easily follow, especially if you are an SME or a regular Joe, because don't forget that these are not only companies like Panasonic or Sony standing on Amazon. These are also SMEs, and these are also regular guys from across the street who are doing something. This gives them the ability to have a simple procedure, and also have a fair ground with other companies that sell on Amazon that are big companies and have to go through the same procedure. But also, if you have enough money actually to go through this whole litigation, if you feel that the arbitration has been done unfairly or there is some suspicion of bribery, you can always go to the regular court to have the decision overturned. This path is never closed, and I don't know why the other parties claim that it is. Yes, I'll keep you on.
Like, obviously, like, tribunals exist in a very wide number of legal systems because obviously legal systems out there are familiar with like the costs of running things as you are.
Yes, of course, tribunals do exist in a variety of legal systems, and you also sell in a variety of legal systems. If you are an SME, even a big company, say that a product has been produced in Europe, like I know where you're based, but say it right there, and your product is sold in the US, in Cambodia, in Germany, you are automatically placed in 3 different legal systems. And if anything happens in any of those, or maybe in all of them at once, you are absolutely unable to hire super duper expensive legal teams to be able to advise you and to go to court in these places, because you will be not in an Amazon court, but in the jurisdiction of the courts of Laos, in the courts of Germany, in the court of the US or a particular state. You will be just simply unable to go through these procedures using tribunals. You also mentioned international tribunals, which will not take a case of a regular Joe. These are huge cases that are going to be arbitrated, that need huge litigation to even get in front of these courts. So this particular part is actually, it sounds nice, but it's absolutely practically closed. Also, the OG said that it is their court. It is not their court, actually. What it is the open source procedure which you can access from any place in the world. It's quite understandable, actually, even for, as I said a couple of times, the regular Joe. And so you know ahead of time. And arbitrators are not employees of Amazon. The way the arbitration procedures work, you have to hire an impartial arbiter from a list of arbiters. So it is not like a company's employee who you can dangle some profits ahead of, in front of their noses. So these are impartial arbiters, and just a simplified procedure right here for you. Okay, and you said that also Amazon has an incentive to make these procedures unfair. Well, let's talk a bit about the incentive of Amazon. What Amazon does is Amazon is a company, so its incentive is first and foremost to maximize profits. Profits come from people using your platform if you're Amazon. So people, to use your platform need to feel safe. They don't, they have to operate in dozen legal systems. So what you need to do is you need to give them this safety. You need to give them a clear open source guidelines and affordable procedures, so they know that if anything happens, they actually have a viable way to pursue their rights, to pursue it in a way that's actually practically manageable. And this is just what Amazon does. It gives you clear guidelines so you feel safe, irrespective of how big or small you are and where you sell, whether it's one country or 10 countries or every country in which Amazon operates. And also, you said something about PR, and let's first say about the cost of PR, and because you said that it would have no impact because people do not know about how third-party sellers are treated. Well, this is precisely what Amazon wants. Amazon has fuck all kind of money. Like it can give you money to settle, it can give you money to reimburse you, but what it cannot afford is going to court with you and showing this big behemoth, this huge Goliath pursuing a small third-party seller or an SME, because it's going to be absolutely fatal PR for them. And as you have shown, their profits come from people being willing to set up the shops on Amazon, which they are not going to do if they do not feel safe, if they feel that this particular Goliath is going to pursue them for every violation they might feel inclined to. Okay, you also said on CG this particular time that Amazon is actually a marketplace which we're obligated to sell because other platforms are not viable. Other platforms are actually terrifically viable. Like the whole world is not just the United States. And platforms such as Alibaba or Oracle in Japan have got total market penetration when Amazon has barely any viable business. Platforms such as Allegro in Poland has got the very same thing. eBay perhaps was a bit crushed, but we live in a diversified world. Amazon is not a monopoly, and definitely like in a worldwide sense, it still has to compete. And what it does, it actually gives you these guidelines and forces other companies which might have been treating you legally bad, such as Allegro, for instance, to also establish their clear guidelines, because now they have to compete with Amazon. And these clear guidelines is something that actually draws customers and sellers onto your platform because they feel safe. And also we said about the impartiality of the courts. Well, first of all, you have the case of the impartial arbiter, but also you need to know that operating in so many systems, many of these systems are not only unaffordable for you, they're also highly corruptible and corruptible for Amazon very easily, since they are well established there. Okay. Yeah, so what we have done also in comparison to friends on the opening. Well, they have stated some very important cases as to why the Amazon has the freedom to craft its offer this way and to give its offer out on the market in this particular manner. They focus more on the end consumer, want to focus more on the seller. And what we have shown is what these guidelines do, and what pushing our sellers towards this direction does, is gives you equal treatment of big and small sellers in the very beginning, because they have to go through the same procedure. They give some viable procedure for the little guy. We have shown you that courts are only theoretically available anyways. We have shown you that this clear procedure also has positive impact on marketplaces in various countries where they have not been established. And we have shown you that it is basically all secured pretty much by the Amazon's most famous incentive, which is profit generation. And I believe it is the end of my time. Thank you.
Great. I thank that speaker for that speech, and I thank all speakers for the debate. Please leave the breakout room and head back to the main meeting room. Please do not leave the Zoom entirely. Thank you. Thank you all for this debate. It was actually a really exciting debate to watch, and while we had initially extremely different calls, we were able to come to a consensus. So I thought that myself, Alexander, Sharon, and Husna had a really good discussion. So after this debate, I would highly encourage you to also look for them if you want additional feedback. Okay, so like I mentioned, we originally had extremely different calls, but our consensus decision eventually was we gave the first to opening government, the second to closing opposition, the third to closing government, and unfortunately, the fourth to opening opposition. And what I'm going to do now is I'm going to start with some general comments about the round that I think all speakers can take note of before going on into specific team by team breakdowns. Okay, so I thought this debate, while good in terms of analyzing what kinds of profit incentives generally drive businesses, was significantly lacking in characterization of what the arbitration process looks like, why the arbitration process is sometimes initiated, what is generally disputed in arbitration processes, and quite importantly, how an arbitration process is different from taking someone to court. So I think all of these things could have probably deepened the level of analysis given in the debate, which eventually ended up fairly one-dimensional and became solely about Amazon's incentives and whether or not Amazon has more of an incentive to play fair to keep people in, or more of an incentive to play unfair to gain profits. So I think there was an additional, perhaps more legal dimension to it that teams could have considered characterizing. In addition, I think probably characterizing what the process is being like or what the resolution process is like would have also helped teams explain why certain things would happen in some way or another. So in this debate, for instance, I think it wasn't until CO Whip that we perhaps had the assertion that this is about independent arbitrators that were sourced from non-Amazon sources. So that, that might have been important information to have earlier in the debate when discussing the process and this issue. Okay, so I'm going to start from opening opposition and work my way up so you can see the individual team by team comparisons. From opening opposition, we've got a couple of issues that we credited the team with. The first is this idea that when you sign the contract, it is free and independent. If you do not like the conditions in the contract, you are absolutely free to not sign it and therefore do whatever you want. So the moment you have opted into the contract, no matter how unfair the contract is, you just have to like stick by it. Tough luck to independent sellers. Couple of things about this argument. The first, I think, is that it is not necessarily fully comparative to the arguments given in opening government about the monopolistic nature of Amazon. So opening government gives some reasons to believe that, first of all, because Amazon has lots of lawyers poring over the details within your contract, Amazon is likely to be able to write the contract in an unfair way that you will then have to accept and cannot opt out of, simply because you are coerced into getting this section of like large market share, as well as into being able to access the consumer base that you need in order to buy your products. The second thing about this argument is that I think closing government points out correctly that this is not so much about the contents of the contract as it is about the means through which the contract is enforced. So while it might be true that you are opting into arbitration the moment you sign the contract, perhaps the thing that you are opting into is inherently pretty unjust. So we should probably ban it in order for like fairness reasons to ensure that you get a fair say when the contract is enforced. The second thing I want to say here is about the monopoly comparison that opening opposition tries to bring. So in addition to this argument, opening opposition also claims that offline retailers and competitors exist, that it is easy to set up a competing site. You can very easily set up your own website and do direct to consumer marketing through social media. So I think all of this is true to a certain extent. I think opening opposition does enough to let me believe that there are options available for you. The question then becomes, how effective are these options given OG's characterizations and arguments that they are not in fact very effective at all? Because I think so long as opening government is able to show that these options are hugely ineffective and difficult compared to Amazon, then in essence, even though you have the option to do this, it is not actually a free option because you are still coerced in some manner into accepting Amazon's procedures. So I think opening government actually points out that even if offline stores exist and even if competing sites exist, Amazon's business model is specifically to drive all of these sites out of business. And if you are setting up your own website, you are unable to have the kind of reach that Amazon would give you. Closing government backs that up by pointing out that Amazon isn't just a marketplace, it isn't just a monopoly, it is the marketplace itself on which all of these other businesses happen. So it's that you need to be on Amazon to even have your item in the forefront of people's radars as they're searching for items. They would never know where to buy things if you don't have Amazon. So I think both of those things put together really cut against opening opposition's claims that Amazon isn't a full monopoly and that you should just opt out of it if you don't like it, because I think there is enough done from opening government and closing government to say you can't really do this. The second thing opening opposition claims is that this is about protecting consumers, and Amazon has an incentive to find a balance between consumers and shops because they earn money from sale commissions and they want sellers and shops to stay on Amazon. So this is, I think, an argument that is slightly underanalyzed in terms of why exactly Amazon wants to maintain shops staying on Amazon instead of jumping ship to eBay. I think you give some analysis that there is some level of profit incentive there, but it's not actually explained how this plays out within the arbitration process, nor do I think it is explained how this interacts with opening government's claims about all of the incentives that arbiters are likely to have in terms of skewing the decision towards Amazon's side. I think in addition, opening opposition's claims are framed in this way about protecting consumers, which actually, while while it is an important debate to have, I think is not really part of this debate, because this specific debate, based on the info slide as well as the motion, as well as the motion clarifications, as well as pointed out by closing government, is actually about vendor Amazon disputes as opposed to disputes between vendors and consumers. So I think a large chunk of the argumentation about why Amazon is the best place to decide these disputes for vendors and consumers actually ends up falling out of the debate, as well as the arguments about consumer protection. The last thing I want to say about this argument regarding consumer protection is that opening government points out there are a couple of mechanisms through which Amazon already protects consumers. So they point out in the DPM speech that Amazon already has strict checks for which suppliers are able to be admitted to the platform, and they also have this ability to refund consumers if it turns out that there was malpractice. So I think all of that leads to the consumer protection that opening opposition wants, while opening opposition is not fully able to show the benefits of having this arbitration existing, nor are they able to show that it's a just system. Okay, so comparing now to what closing government brings. So I think I already did some material here about closing government's arguments against opening opposition's no obligation on sellers' part to sell on Amazon argument. In addition to that, I think closing government brings a couple of things. The first is that they point out that tribunals maybe exist in certain instances, and these tribunals might be useful in terms of people bringing their complaints. So that seems to provide an accessible way for people to, seems to provide a plausible alternative for vendors that need to go through Amazon disputes. The second thing closing government points out is that it leads Amazon to have a massive competitive advantage, because no one is ever going to win a suit against you at the point when you are using pretty much your own arbiters and your internal court system. So this means that Amazon doesn't have to pay out damages, and it leads them to be more willing to breach contract and screw over business partners because they know they will not be held accountable. I think this gives me sufficient reasons to believe that these like internal arbitration mechanisms are not a sufficient check on bad Amazon behavior. So even if I buy that the best thing to do is to protect consumers from opening opposition, closing gov gives me some reasons as to why Amazon behavior gets worse when we have this thing with internal arbitration. The last thing closing government points out is that Amazon needs to attract, doesn't actually need to cater to customers and investors, because Amazon is Amazon. Nobody is going to pay attention to Amazon's third-party contract enforcement, and strong-arming vendors can actually make Amazon more attractive to investors because this helps them drive profit. So again, I think that cuts against opening opposition's very brief claim that Amazon wants to increase sales, and that's why they will carry out this arbitration in a good manner. Okay, so now comparing closing government to closing opposition. All right, so two things to say here. The first is that I think this argument that you give about Amazon not needing to do this in order to attract investors and sellers, while responsive to opening opposition's claim, is not fully responsive to what CO claims, which is that Amazon has an incentive to do this properly because of the cost of PR of doing it poorly, where if it goes poorly poorly, they cannot actually afford to go to court with you to show a monopoly pursuing a small seller, that it needs to be done well, because if not, sellers and vendors can raise an issue about it in public, that there are alternative means where you can actually appeal these kind of procedures. All of these things show that there are perhaps at least some checks so Amazon doesn't run as wild as CG is claiming. The second thing that CO claims against this is that Amazon needs sellers to, in some sense, feel safe using their platform. So while it is true that I think there is a monopoly there, the bulk of the monopolistic analysis, I think, comes from opening government. So this is compared directly to what CG brings, which is this idea about customers and investors, right? And I think CO does enough to point out that this, at the very least, provides clear, open guidelines and affordable procedures so that if anything happens, vendors know there is at least some option for them to pursue their rights, compared to a court system, which is expensive and time consuming, and you need tons of lawyers for it. I think CO points out late, but probably correctly and in response, that a lot of these things that CG is claiming, which are things like going to courts and not really tribunals, because tribunals are a bit limited, but going to court really advantages large corporations as opposed to small corporations. And so it's better for us to have a system where all corporations of various sizes are equalized in a sense and can all access some kind of justice. This also cuts against CG's claim that is a massive competitive advantage because no one can win arbitration against Amazon. Because the effectiveness of this argument, when you are comparing it, really depends on CG being able to show that companies will be able to win in open court. And I think CO gives sufficient reasons to believe that companies are not going to win in open court, but due to the expense and due to the fact that Amazon is the largest corporation in the world and you are in multiple legal systems, so you're unlikely to win or go bankrupt. I think all of that means even if you are unlikely to get a really good outcome in arbitration, you are even less likely to get that kind of outcome in open court. So that's how CO takes it over CG's two arguments. Okay, now doing the last comparison against opening government. Okay, so I think maybe I will just do a quick summary of what opening government says. Opening government, I think, gives a lot of analysis for why Amazon is hugely monopolistic. They say you are coerced into using Amazon, into signing contracts. It kills competitors. Brick and mortar shops are less competitive. There's a vertically integrated supply chain. Basically, a lot of reasons why Amazon or opting into Amazon is coercive in the first place. The second thing they point out is that contracts are always going to be tilted towards Amazon, that lawyers are subconsciously biased and going to be on Amazon's side. And even if they are independent judges, you do not trust the process, because you do not believe you can prove or win anything against Amazon. And here they also point out that this means there is a reduced number of cases brought against Amazon in internal arbitration. How then does this compare to closing opposition? Okay, so I think closing opposition's claims that Amazon has an incentive to do things properly falls out against OG's monopolistic argument. Like all this stuff about how they need clear open guidelines to ensure people feel safe, I think only works if you can disprove OG's argument that people are coerced into staying into Amazon precisely because it opens such a huge consumer base to them. So even if Amazon treats you like crap, you will still stay there. I think the response to this that CO tried to give is basically Amazon is most monopolistic inside North America. This is not true elsewhere in the world. But I will point out that saying it is most monopolistic in North America is not the same as showing everywhere else it is not monopolistic, just that it's monopolistic to more or less degrees. And I think OG gives sufficient reasons to believe that even in various contexts, there are certain advantages that it has that means that it's going to be really difficult for you to opt out of it if you stay in certain regions, pretty much. Okay, I think the cost of PR argument brought by CO also relies on people being able to bring you to court in the first place, right? Where CO basically says you cannot afford to go to court to show the monopoly pursuing a small, medium enterprise. I think all of this relies on people bringing cases in the first place. And OG's argument shows that because people do not trust the process, they are actually very unlikely to bring cases to arbitration at all, meaning that you lose this mechanism from CO about why Amazon is going to be kept in check and behave properly. The second thing OG points out is that the second thing Amazon points out is that Amazon has more money to pay for lawyers, and all of this stuff tilts a massive advantage to Amazon. Okay, so I think CO correctly points out that this is symmetric in terms of courts as well. And I don't think OG really does that much to show that courts are the most effective mechanism. But what I think happens is that OG does enough to show that arbitration itself is probably going to be super problematic and cut out individuals from accessing justice, where individuals will perhaps be more willing to bring cases to court, even if it is just as messy and expensive as CO points out, due to their perceptions of how biased Amazon is. The last thing CO says in response to this is this idea that there will be independent mediators. I actually do think that's a bit late, to be quite honest. I think it's a bit late to characterize all of these arbiters as being independent from CO whip. I think perhaps if there was greater characterization given in the extension speech, as opposed to just like a one-liner assertion towards the end, it might have worked better. But based on the material given within both speeches, as well as the material given from OG and DPM that was preemptive, I think OG very narrowly takes it over CO due to the monopolistic mechanisms, taking it over the Amazon incentive to do it properly mechanisms. Okay, cool. Thank you for the debate. Very good round. Sorry for taking so long. Please head back to main room.